and start admitting folks.
Thanks, James. Hello, welcome. Good to see you. We're going to give everybody about 5 minutes to join in, so we'll go ahead and get started at 10:35. Anybody needs to test their camera or microphone, you're welcome to. We'll get started here in a few minutes at 10:35.
Thanks, Derek. Can you hear me?
Yes, yep.
Wonderful.
We'll give everybody just a few more minutes. I know sometimes people are coming from other meetings and timelines can be tight, so we'll start at 10:35. All right, we'll give it one more minute and then we'll go ahead and get started. I'm going to go ahead and get my screen shared here. Okay, it's 10:35, so let's go ahead and get started. We may have some additional people that join us as we do our introductions. Welcome everybody to today's Senate Bill 163 Rule Advisory Committee meeting. I appreciate you all being here and taking time out of your very busy schedules to provide important feedback on these rules. My name is Derek Patterson, and I am the liaison to the County Vital Records offices for the Center for Health Statistics. And I will be facilitating this meeting and each of our RAC meetings through the month of July. As you can see on the agenda, we're going to review 3 proposed rule drafts today. We will be reviewing different rules at our next Rule Advisory Committee meeting and at the 3rd. We will also be reviewing some documents related to rulemaking, such as the Statement of Need and Fiscal Impact that talks about fiscal impacts of the rules as well as equity impacts. The rules that we're going to look at today are related to adding parents on a birth report who intend to marry or enter into a domestic partnership, and 2 rules related to voluntary acknowledgments of parentage, one for witnessed, which is the ones in birth facilities, and one for the notarized version, so outside of birth facilities. Let's take a look at our agenda real quick before we jump in. We're going to go over some meeting procedures and housekeeping things and do some introductions. This might take a little bit longer this time around than in future meetings, just since it's our first. And then we want to spend the bulk of our time reviewing the proposed rule drafts and collecting feedback from RAC members. And then at the end, we'll have some next steps, and then this meeting will end at noon. Let's go ahead and jump into introductions. I've got a list here of our Rule Advisory Committee members. If you want to be on camera, we encourage you to, but understand that sometimes there's bandwidth issues and other things, so you don't have to. What we could do is I can just go through this list and we'll just start at the top. I'll just read each name. If you're here, if you'd like to unmute yourself and introduce yourself, let us know which organization you're with or what group of people you represent. That will help us to know who's here. Let's start at the top. Jennifer Diaz.
Hi, I'm Jenny Dees. I'm the nurse manager for the Mother Baby Unit at Providence, Portland, and work closely with our birth clerk. So very interested in this work and being a part of it. Thank you.
Excellent, thank you. Robin Pope. Lane Shetterly.
Yeah, Lane Shetterly here. I was chair of the legislative work group that put Senate Bill 163 together, a member of the Uniform Law Commission. The Uniform Parentage Act is a product of the Uniform Law Commission. Not a practitioner in this area, but I'm interested in just the implementation of it. And incidentally, I'm at the annual meeting of the Uniform Law Commission in Chicago, even as we speak. So they were very glad to hear that we had some rulemaking going on in Oregon today.
Excellent, thank you for joining us. Beth Wolfsong. Jennifer Wolfsong. Let's see, we have Ming Wong. Paula Amato. Maura Roche.
Hi, I am present, Maura Roach, Basic Rights Oregon. And I think, did we get Robin Pope on this earlier? Because
I'm here. I'm here. Hi. Whoops. Oh, wait.
Yes, we'll circle back to you. Perfect. Yeah, thank you. Robin, would you like to we're just doing introductions. If you just like to share which organization you're with or who you're representing on our rack today.
Sure. Sorry about that. I had trouble getting onto Teams. I'm an attorney in private practice. I was on the work group with Lane, helping to write and lobby and get past the Senate bill, and a longtime attorney doing family law, adoption, and assisted reproduction law.
Perfect. Thank you, Robin.
You're welcome.
Tabitha Coe. Looks like you might still be muted if you're talking.
Okay, did Maura get to do her introduction?
I did. It wasn't that exciting. Maura Basic Rights Oregon. I've been their lobbyist and government relations person for a number of years. Glad to be here.
I would never take airspace from Maura, who I love to hear from. I'm Tabitha Coe. I'm a adoption and assisted reproduction practitioner in Oregon of many years. We file a high volume of surrogacy and parentage related cases and lots of different kinds of adoption. So I'm excited to be a part of this group. And I was also able to be on the work group for the UPA.
Thank you. Do we have Sophia Hirons? Allison Kassler? Anita Rojas? Julie Kornelkin? Amanda Hess? Laura Curtis? Elizabeth?
I'll just
oh, yeah, go ahead.
Sorry, but Amanda and Laura are tasking me with this work group, so they will not be joining us.
Perfect. Thank you.
And actually, Elizabeth Figlio, who I see you're coming up with, that was just an error. She's my assistant who helped with the scheduling, so she can come off the list.
Perfect. Thank you. Sean Colmer. Kara Stecker. Richard Vaughn.
Good morning, everyone. My name is Richard Vaughn. I'm the incoming chair of the American Bar Association section of family law. I'm a Quad A member. I'm a former observer and ABA liaison to the Uniform Law Commission Uniform Parentage Act Drafting Committee prior to the enactment of the 2017 UPA. I've been a longtime practitioner in the assisted reproduction arena, including being heavily involved in getting the ABA model acts governing assisted reproduction passed in 2019.
Thank you, Richard. Beth Allen. Brent Leonhard. Kendall Mason. Amy
Again,
Down.
sorry.
Oh, go ahead.
Kendall's the executive director of Basic Rights Oregon, and Beth Allen must be, is that Judge Allen? She's retired. I don't think that's happening.
Thank you. Amy Down Mall.
Hi, good morning. I'm Amy Downwall from the Hospital Association of Oregon, and neither Sean Colmer, also from the association, nor Danielle Meyer will be participating.
Thank you.
Mhm.
And Danielle Meyer. Okay. Is there anybody we missed that joined in as we were going through that's part of the rack here? All right, let's go ahead and introduce our subject matter experts and support staff, many of whom are with the Center for Health Statistics. Let's start with Jennifer Woodward. Would you like to introduce yourself?
Sure. Thank you. Good morning, everybody. Thank you for joining us and taking time to meet today. I'm Jennifer Woodward. I manage the Center for Health Statistics, and I'm a subject matter expert. Thank you, Derek.
Thank you, Jennifer. Danny Hall.
Thanks, Derek. Danny Hall. I am the Center for Health Statistics Partner Services, operational support analyst. And so I will just be providing support to Derek. So thanks everyone for being here.
Thank you, Danny. James Crocker.
Good morning. I'm James Crocker. I also support the Partner Services Training and Communications team here at the Center for Health Statistics, and I'm also assisting Danny with our rule coordination for SB163 implementation.
Thank you. Ian Robbins.
Hello, everyone. I am Ian Robbins. I'm an OVERS business analyst with CHS with a bit more focus on the system side, but I am the project manager for our CHS implementation. Thanks for being here.
Thank you. Karen Rangan.
Thanks, Derek. My name is Karen Rangan, and I manage the Partner Services Training and Communications team here at the Center for Health Statistics, and I'm here to support the team.
Thank you. Joanna Collins.
Thanks, Derek. Good morning, everyone. My name is Joanna Collins, and I manage the amendment unit for the Center for Health Statistics, and I am joining as a subject matter expert today. Thank you.
Thank you. Erin Williams.
Thanks, Derek. My name is Erin Williams. I'm one of the attorneys that represents OHA and has been working with the Center for Health Statistics on rule drafting.
Thank you, Erin. Is there anybody that has not had an opportunity to introduce themselves yet? Okay. So a couple of things before we jump into reviewing the rules. Some important things to remember. This is a public meeting in that we are recording it, and any feedback that you provide as part of this RAC will be public record. So that's important to keep in mind. Also, it's important to know that only RAC members can provide feedback in this meeting. So if you're not a member of the RAC, there is an opportunity later in this process during the public comment phase, which will take place after all of the Rule Advisory Committee meetings, for anybody to provide feedback. Or if there's other things that you think of later that you'd like to include, there is that. As far as the format for collecting feedback, what we'll do is I will read a short summary from our notice of proposed rulemaking for each rule, and then we will read through the rule one section at a time. I'll pause after each section, and if you're a member of the RAC, feel free to raise your hand and unmute yourself and provide feedback. Or if you prefer, you can put it in the chat. We do hope that we can minimize side conversations in the chat. And I won't, in the interest of time, I won't be reading each chat out loud, but our support staff are going to keep track of that, and any feedback that is provided in that chat will be taken into account. Also, questions in this process are really great. They're going to help us to know what we might need to potentially change in the rules, as well as what things might need clarified. But our focus today isn't going to be on answering questions or coming to conclusions. We're going to be focused on using the time to collect questions and feedback from each of you that we can consider. Our subject matter experts are available, and they might chime in if there's something that they can clarify or that would be helpful for the RAC, but we won't focus on coming to a conclusion on every question. Before we jump in, just a brief overview of Senate Bill 163. I think this is legislation you're all very familiar with, but to set the stage, this is related to establishing parentage for children in Oregon. It passed in the 2025 legislative session, and it was a pretty large bill. There was a lot of changes for vital records. Some of those changes became operational January 1st of 2026, but most of the substantive changes for vital records work become operational on January 1st of 2027. So as a result, we need to change some of our rules, add additional rules, update our forms, and update our electronic system. So today we'll be focused on the rules portion. We did provide copies of drafts of a lot of the forms that we're working on to you, just for your information and background, but we won't be reviewing those during these RAC meetings. We are planning to do a work group that will look at the forums and provide feedback on them. So if that's something that you're interested in participating in and providing feedback on those, our support staff will put an email in the chat that you can email us and reach out if that's something that you're interested in. Some other things to know about these rules is there has been some review of them already. The Department of Justice, the Division of Child Support, the Oregon Department of Human Services, and the Oregon Judicial Department have all had a chance to review these rules. And we're looking forward to getting feedback from all of you as well. Any questions before we start into the rules themselves?
Just one, Derek. Mm-hmm. Curious if the review by OJD and DOJ others, did they make any revisions in the draft rules that were presented to them, or did they come out clean?
I believe that there were some changes that were made from their suggestions.
They're reflected in what we're seeing today. Okay.
Yes, that's my understanding.
Okay, thanks.
A subject matter expert will correct me if I'm wrong there. All right, great question. Any other questions before we start? Just going to check the chat here. Okay, not hearing any. Let's go ahead and start. The first rule that we're going to take a look at is OAR 333-011-0262. These summaries are from our Notice of Proposed Rulemaking, just to set the stage. Adding parents on birth report who intend to marry or enter into domestic partnership establishes the process by which parents who are not married at the time of the child's birth may agree to add the second parent to a child's birth record by affirming their intent to marry at a later date. This rule is needed to clarify the requirements that must be met for a second parent to be added to the birth record based on the intent to marry, including that the parent must indicate their agreement to be added to the birth report by signing the birth worksheet. It identifies obligations for individuals reporting births where the second parent requests to be added to the birth record based on the intent to marry. Okay, now we'll go through each section. I'll pause briefly after each section in case anybody wants to provide comments or feedback or has questions. If you think of something later, it's okay to provide feedback on something that we've already covered. If we're on 3 and you think of something for 1, that's fine. And yeah, feel free to raise your hand and jump in. So, okay, section 1. For the purposes of this rule, reporter means the person who submits a report of live birth to the Center for Health Statistics, CHS, as described in ORS 432.088, sections 3 and 5. Reporter may include acknowledged parents, alleged genetic parents, intended parents, institutions, persons in charge of the institution, or physicians as defined in ORS 432.005. Direct entry midwives, midwives registered with CHS, the parent who gave birth, any other parent, a person in charge of the premises where the live birth occurred, or any other person who submits a report of live birth to CHS. Section 2. For purposes of this rule, second parent means the individual who is not the parent who gave birth and seeks to be added to the birth record for the child under this rule. Section 3. If a parent who gave or will give birth to the child is not married at the time of either conception or live birth, or within 300 days before the live birth, the second parent may be entered on the report of live birth if A, the parent who gave birth or will give birth to the child and the second parent intend to marry or enter into a domestic partnership registered by the state after the birth of the child, and B, the second parent agrees to be added to the record of live birth. Any questions or feedback so far? Okay, section 4.
Derek,
Oh,
it
yes,
looks like Tabitha has a hand up.
Thank you.
I just have a practical question.
Mhm.
If we're talking about a report of a live birth, then how would the circumstance of a parent who will give birth arise? Because the certificate is filed, the report is filed after a baby is born.
Mhm. Thank you. That is a good question.
I'll chime in.
Yeah, go ahead, Jennifer.
Thank you, Tabitha. So definitions in our statutes, a report is prior to the birth and a record is after the birth. So they could submit the worksheets prior to the birth, if you know, because in some facilities the worksheets are prior. So there's a key definition between report and record of birth.
Thank you.
Thank you, Jennifer. And thank you, Tabitha. Good question. Any other questions or feedback before we move on? All right, section 4, to add the second parent on the birth report under this rule, the following must be submitted on the birth filing worksheet for parents in the form required by CHS. A, indication the parent who gave birth and second parent intend to marry or enter into domestic partnership registered by the state. B, the signature of the second parent indicating they agree to be added to the birth record. C, information for the second parent, including name, date of birth, and other information required in the worksheet. D, any other information as required by the state registrar in the birth worksheet. And E, the signature of the parent who gave birth or their designee as the informant, verifying the accuracy of the information provided on the worksheet. Okay. 5, a reporter shall complete the report of live birth and include the second parent using the information provided on the birth worksheet if A, the birth worksheet has been signed by the second parent indicating agreement to be added to the birth report, B, the requirements under section 3 of this rule have been met, and C, the birth worksheet does not indicate that the parent who gave or will give birth to the child was married at the time of either conception or live birth, or within 300 days before the live birth. Any questions or feedback? Okay. Section 6, a reporter shall not include the second parent on the birth report, and the state registrar shall not include the second parent on the birth record if A, the second parent has not signed the worksheet indicating agreement to be added to the birth report, B, any requirement under section 4 of this rule has not been met, or C, the birth worksheet indicates that the parent who gave or will give birth to the child was married at the time of either conception or live birth, or within 300 days before the live birth. Okay. 7, when processing a request under this rule, if the state registrar has cause to question the validity or adequacy of the documentation, the state registrar, in the state registrar's discretion, may request additional information or documentation, or may refuse to register the live birth or amend a record of live birth. Any other questions or feedback about that rule? Okay. So the next rule that we're going to cover is OAR 333-011-0266. This is related to witnessed voluntary acknowledgements of parentage. The summary for this is witnessed voluntary acknowledgements of parentage establishes the witnessed voluntary acknowledgement of parentage form as required by ORS 432.098-1A. The rule also establishes the requirements for completing and submitting the form to add a parent to a birth report. In addition, the rule specifies when a form is insufficient or when the proposed parent will not be added to the birth record. The rule also identifies obligations for individuals reporting births where a witnessed voluntary acknowledgement of parentage will be submitted. All right. Section 1, for the purposes of this rule, parties is defined to A, include the parent who will give or gave birth to the child, the alleged genetic parent as defined in ORS 109.002, presumed parent as defined in ORS 109.002, or intended parent as defined in ORS 432.005. B, exclude an intended parent as defined in ORS 432.005 when the child was conceived by assisted reproduction under a surrogacy agreement. Okay. Section 2. This rule adopts the witnessed voluntary acknowledgement of parentage form as required by ORS 432.098. A voluntary acknowledgement of parentage must be completed on the form prescribed by the State Registrar of the Center for Health Statistics, CHS. The form is available upon request from a healthcare facility where the birth will occur or occurs. The form is also available upon request from CHS. All right. 3, the witnessed voluntary acknowledgement of parentage form must request or require information necessary to comply with existing federal and state laws and regulations for determination and recording of parentage, including but not limited to A, current full names of the child and the parties, B, social security numbers of the parties if available, C, dates of birth for the child and parties, D, birthplaces of the parties, E, addresses and phone numbers of the parties, F, birthplace of the child, hospital, or healthcare facility, G, statement indicating the parties need to read and understand the form and that making willful and knowing false statements on this form can lead to criminal and civil penalties, H, statements of acknowledgement signed by both parties, I, signature lines for the parties, J, signature lines for the witnesses, and K, statements of rights, responsibilities, alternatives, and consequences specified in ORS 109.070. Any feedback or questions about?
Derek,
Yes.
just a really minor grammatical one, but in G, it seems like combining the and this in that sentence is odd. I would think it would probably be statements on the form, because in the rule, we're not looking at a form, we're talking about a form.
Perfect.
And
Thank
you
you.
use the form in the first line of that subsection too.
Let's see.
Of G, statements
Here.
Statements indicating the parties need to read and understand the form and making willful and acknowledging false statements on this form. I think that would be the too.
Okay. Thank you. Any other feedback?
Can I ask
Okay.
a clarifying question?
Sure.
Derek?
Yeah,
Um,
absolutely.
This is Jenny Dees, the nurse manager at Providence, Portland. Just asking, is this now changing Is this recommendation is that we're asking that the statement is read and understood by the parents, the intended parents. Because currently the way it reads, we are required to read it to them.
Thank you. Do any of our subject matter experts want to chime in on that? If not, we can take it into account for our future versions.
And I want to add that I like that it just says that they read it personally, because it does take quite a lot of time for us to read it to them.
Thank you, Jenny. Erin.
I can clarify if you'd like. This is just establishing that the VAP is going to include this statement saying parties need to read and understand this form. And the requirement that the certain acknowledgements be read by the hospital staff to the parties is still a statutory requirement, so that will remain. This is just saying that the actual form will say, hey, parties, you need to read and understand this form before you sign it.
Okay, thank you.
Thank you, Erin. Let's see, were there any other hands on that one that anybody wanted to add anything? Okay. All right, section 4. Staff at the healthcare facility where the birth occurred shall provide the witnessed voluntary acknowledgement of parentage form to the parties before, at, or after the birth of the child if there is reason to believe that A, the parent who gave birth to the child is not married or in domestic partnership registered by the state. B, the parent who gave birth to the child is married or in domestic partnership registered by the state, but the alleged genetic parent of the child is not the spouse or registered domestic partner of the parent who gave birth to the child. Or C, the child was conceived by assisted reproduction other than under a surrogacy agreement. Any feedback on that section? Okay. Section 5, a witnessed voluntary acknowledgement of parentage must A, be fully completed with all required fields filled out, B, not contain any crossed out or altered information, C, be witnessed by a staff member of the health facility where the child was born within 5 days following the child's birth, D, be signed and dated by all parties identified in the form while witnessed by facility staff. All signatures must be original and may not be stamps or electronic signatures. The date of signature by the witness must match the signature date of the party whose signature was witnessed. E, only be signed after facility staff reads to the parties the rights, responsibilities, alternatives, and consequences listed on the acknowledgement. Any questions or feedback about that section? Okay. Section 6, the parties are responsible for accurately completing the form and returning the completed and signed form to the healthcare facility staff for submission to CHS. Each party should retain a copy of the completed signed form. Seven, the state registrar shall only accept a witnessed voluntary acknowledgement of parentage form that satisfies the requirements in this rule and applicable statute. 8, the person in charge of the healthcare facility where the birth occurred or an authorized designee shall enter the information regarding the alleged genetic parent, presumed parent, or intended parent from the witnessed acknowledgement of parentage form into the state registrar's electronic birth reporting system. If the information on a parent worksheet for the party seeking to establish parentage differs from the witnessed voluntary acknowledgement of parentage form, healthcare facility staff shall input the information from the acknowledgement form into the birth report. Any questions or feedback? Okay.
Derek?
Yes, Lane. Yep.
Sorry, this is Lane again, and I'm just exposing my ignorance of this, but looking just at the rule in, is it 5C, it says that the form has to be witnessed by a member of the health facility, staff member within 5 days following the child's birth. Is there a corresponding time limit within which the form must be signed by the parent? I mean, I guess if it has to be witnessed within 5 days, it's implicit that it needs to be signed by the parent before 5 days. But is there an explicit rule to that effect? It's kind of funny to have the time limit addressed to the witnesses, but not to the actual execution of the form.
I think subject matters will correct me if I'm wrong, but I think in D, they have to, the date that they witness has to be the same as the date it's signed. So it all have to take place on the same day before 5 days.
Okay.
Is my
It just
understanding.
seems to me as a matter of drafting, it's kind of odd to put the time limit on the witness's signature, but not on the parent's signature. But I guess if that's not confusing to folks, it will never confuse me.
We appreciate it. Any other feedback or questions? Okay. Thank you. Great feedback. Let's see. I scrolled. Don't let me accidentally skip something. I think we're on 9. Okay, yes. The healthcare facility shall mail complete witnessed voluntary acknowledgement of parentage forms to CHS at least weekly. 10. When a birth report indicates a witnessed voluntary acknowledgement of parentage form was completed, the state registrar shall register the birth to include the parent added by the witnessed voluntary acknowledgement only after A, receiving and accepting a witnessed voluntary acknowledgement of parentage form if no second parent is named on the child's report of live birth, or B, receiving and accepting a witnessed voluntary acknowledgement of parentage form and a denial of parentage form as described in OAR 333-011-0268 if there is a second parent named in the report of live birth. Any questions or feedback? Okay. Section 11. If a witnessed voluntary acknowledgement form is not received and accepted by the state registrar, as described in Section 10A of this rule, within 45 days from the date of birth, the state registrar shall register the birth without the parent identified in the report as submitting a witnessed voluntary acknowledgement of parentage. Witnessed voluntary acknowledgement of parentage forms received by CHS shall be held for matching with birth reports, birth records, or denials of parentage forms until matched or for 6 months after receipt, whichever is earlier. Unmatched notarized voluntary acknowledgement of parentage forms will be retained for to be determined number of years, then destroyed. Any questions or feedback on that section?
Sorry, one question on there. That last sentence refers to notarized forms, but this is the rule on witnessed forms. Notarized forms is the next rule.
Excellent, thank you. Anything else? All right. Section 13. When the state registrar has cause to question the validity or adequacy of documentation submitted under this rule, the state registrar, in the state registrar's discretion, may request additional documentation or refuse to accept the witnessed voluntary acknowledgement of parentage. All right, any other final questions, feedback, anything at all? Tabitha, yeah.
I just want to have a clarifying question for the subject matter experts. It looks to me like this is contemplating that the VAP has to be signed and witnessed within 5 days of the birth, but that there might be a delay of up to another 40 days before it's actually filed with the state. And are we imagining that that's to encompass potential delay in hospital processing, or that individuals will have their VAP with them and delay filing it? I'm just not understanding the circumstance that's trying to address.
Thank you. Would any of our subject matter experts like to answer that?
Yeah, I'll chime in. Thank you for the question. Yeah, I think that the idea is that, you know, we did ask the hospitals to get them in to us within a weekly, but we also want to give a little bit of a time frame for mailing because they do mail. And so we just want to give that opportunity to still get them in. So then we have situations where the mail could take a long time, they get processed here, so we want to give the benefit of the doubt for that time frame. But the goal is to get them and processed as quickly as possible. We have to get them in the office.
Got it. No, that makes perfect sense. I know some rural hospitals have one clerk that might not come in very often to deal with these things. So thank you.
Thank you. Any other questions or feedback? All right, our next one is the notarized voluntary acknowledgement of parentage, 333-011-0267. Notarized voluntary acknowledgement of parentage establishes the notarized voluntary acknowledgement of parentage form as required by ORS 432.0981A. The rule also establishes the requirements for completing and submitting the form to add a parent to a birth record. In addition, the rule specifies when a form is insufficient or when the proposed parent will not be added to the birth record. The rule also identifies obligations for individuals reporting births where a notarized voluntary acknowledgement of parentage will be submitted. The rule also establishes when a fee to add a parent using a notarized voluntary acknowledgement of parentage is required. Section 1, for the purposes of this rule, parties is defined to A, include the parent who will give or gave birth to the child, the alleged genetic parent as defined in ORS 109.002, presumed parent as defined in ORS 109.002, or intended parent as defined in ORS 432.005. B, exclude an intended parent as defined in ORS 432.005 when the child was conceived by assisted reproduction under a surrogacy agreement. Any questions or feedback? Okay, Section 2. This rule adopts the notarized voluntary acknowledgement of parentage form as required by ORS 432.098. A notarized voluntary acknowledgement of parentage form must be completed on the form provided by the state registrar, which is available on the Center for Health Statistics CHS website or upon request. Section 3. A notarized voluntary acknowledgement of parentage form can be signed before or after the birth of the child, but takes effect upon the birth of the child or the filing of the form with the state registrar, whichever is later. If a voluntary acknowledgement of parentage form and a denial of parentage form are both required, Neither is effective until both are filed with the state registrar. Questions or feedback on those sections? Okay. Section 4, the notarized voluntary acknowledgement of parentage form shall request or require information necessary to comply with existing federal and state laws and regulations for determination and recording of parentage, including but not limited to A, current full names of the child, B, current full names of the parties, C, social security numbers of the parties if available, D, date of birth for the child or the expected date of birth, E, dates of birth for the parties, F, birthplaces of the parties, G, addresses and phone numbers of the parties, H, birthplace of the child, I, statement indicating the parties need to read and understand the form and that making willful and knowing false statements on this form can lead to criminal and civil penalties. J, statements of acknowledgement signed by both parties. K, signature lines for the parties. L, space for notary information, signature, and notary stamp. And M, statements of rights, responsibilities, alternatives, and consequences specified in ORS 109.070. Any feedback or questions on those?
Derek?
Yeah, Elaine.
Yeah, just the same comment in I as I made in the previous rule, the and this.
Thank you. Appreciate it. Any other comments? Okay. Section 5, a notarized voluntary acknowledgement of parentage form must A, be fully completed with all required fields filled out, B, not contain any crossed out or altered information, C, include a complete and valid notary section with signature and date by a notarial officer, D, contain original signatures, E, match the child's full name if known, date of birth or expected date of birth, parent who gave birth's current name and name prior to any marriage, maiden name, in the birth report or birth record. For an expected date of birth to match a date of birth, the expected date of birth on the form must fall within 120 days of date of birth on the birth report. Any feedback on that section? Okay. Section 6, the state registrar may require additional information from the parties to match the notarized voluntary acknowledgement of parentage form to the birth report or birth record. 7, the parties are responsible for accurately completing the notarized voluntary acknowledgement of parentage form and mailing the original completed form to CHS at the address identified in the form. Section 8, notarized voluntary acknowledgement of parentage forms received by CHS shall be held for matching with birth reports, birth records, or denials of parentage forms until matched or for 6 months after receipt, whichever is earlier. Unmatched notarized voluntary acknowledgement of parentage forms will be retained for to be determined number of years, then destroyed. Questions or comments on number 8? Okay.
Hi there, this is
Yeah.
Amy from the Hospital Association of Oregon. I had just a kind of a clarifying question. That I see the notarized form also includes a statement of rights, responsibilities, alternatives, and consequences. Is there a reason why it's not read aloud for the notarized version as opposed to the hospital staff version?
Thank you. Appreciate the question. Is that something our subject matter experts can answer?
Yes. Yes, it specifies in that it's the hospital staff that needs to read the witnessed voluntary acknowledgement of paternity versus the notarized one. So the law does state it needs to be read by the hospital staff.
For the witnessed one. Okay.
Yes, for the witness one. Thanks.
Yep. Thank you, Jennifer. Thank you for the question, Amy. Any other questions or comments about this section?
Again, just to clarify, thank you.
Yeah.
Once the forms are matched, is it the plan then that they will be destroyed sort of immediately as soon as we've matched them? So we wait till the 6 months, whatever's been matched is matched, and then they are destroyed and only the unmatched ones are retained? Or is there, we can't retain all this information indefinitely, but I guess I'm interested in what the practice will be.
Thank you. Do any of our subject matter experts like to speak to that?
Yeah, I'll step in. So the key thing is for those that are matched, those are considered legal documents. So anything that is matched, so if we get a voluntary acknowledgement of paternity that's notarized and or witnessed, that is considered the legal change to the record. So those are stored in perpetuity. The questions we have here is if we don't get a matched one and they're unmatched, how long do we retain those unmatched records? Because nothing has come in after 6 months. And that is why we have, we're still trying to determine through our retention schedules and work, you know, your thoughts on this as well as on how long should we be keeping those unmatched voluntary acknowledgement of paternities or notarized paternity forms when we haven't got a match. So, but the matched ones are permanent records and they follow our permanent record retentions and they are put in files. So they are a permanent record.
Okay, great. So in a situation where somebody submitted a VAP, they were matched, and maybe that couple is planning to place a child for adoption down the road, and we're searching for paternity information, that would be available to the state of Oregon to provide. That's great. I mean, my own opinion on how long unmatched forms need to be kept. You know, I do see situations where clients thought they had completed a VAP, but they didn't, or they thought they had acknowledged parentage and they didn't, and it takes them a couple of years before this all sort of comes to light. But because we have such a short timeline that we're wanting to get the sort of claiming of the child, the witnessing, what is their legal intent and their status at that time of birth, I would feel like a couple of years is plenty of time to hold on to those. That's just as a practitioner in this area, that's my view.
Thank you, Tabitha. Is there anybody else that has feedback on the retention time period? Okay. Any other questions or feedback on this section? All right. Thank you all. Some great feedback and questions. Section 9. The state registrar shall only register a birth or prepare a new birth record to add a parent identified in a notarized voluntary acknowledgement of parentage form. A, if there is no second parent named on the child's record of live birth, or B, if there is a second parent already named in the report of live birth or record of live birth, and the registrar has received and accepted a denial of parentage form as described in OAR 333-11-0268, and C, after receiving and accepting a voluntary acknowledgement of parentage form, and D, after receiving required fees. Feedback or questions on that?
Sorry, may I make a comment?
Yeah, absolutely.
I think this is getting at what are the requirements if we're trying to use that VAP, to the notarized VAP, to get the parent added. But it's not the exclusive method. So somebody who attempts a voluntary acknowledgement where there was already a parent listed, a second parent listed, and they don't provide that denial of parentage, I would expect they then move to a court proceeding to determine which of those two potential second parents is the legal one. And then that would be provided to Vital Records. So I would suggest or want us to consider just saying under 9, the state registrar shall only register a birth or prepare a new birth record to add a parent based on a notarized voluntary acknowledgement if, because that parent identified in the notarized VAP could be added through another mechanism. And if I'm too far in the weeds, that's just fine. You can ignore me.
Thank you, Tabitha. I appreciate the feedback. We appreciate it. Any other suggestions on section 9? Okay. Section 10, the state registrar shall establish a replacement for the record of live birth after amending a record of live birth under this rule when a replacement record is requested. A fee is not required to amend or add a parent pursuant to an accepted notarized voluntary acknowledgement of parentage form if the form was received by the state registrar, A, via mail postmarked within 14 days of birth of the child, or B, via mail postmarked within 30 days of the date the state registrar rejected a witnessed voluntary acknowledgement of parentage form. Any questions or feedback? All right, section 12. When the state registrar has cause to question the validity or adequacy of documentation submitted under this rule, the state registrar, in the state registrar's discretion, may request additional documentation or refuse to accept the notarized voluntary acknowledgement of parentage form. Any final questions or feedback about this notarized acknowledgement of parentage rule? Okay. Well, we're done a little bit early. Any other questions before we talk about next steps? Okay. Well, I appreciate you taking time out of your busy schedules to provide us with your feedback. It's really important. We really appreciate it. We will meet again next week at the same time in a very similar format to look at the next 3 rules. We will send you reminders, and just as a reminder, there is that email in the chat if you are interested in joining our forms work group or providing feedback on those forms. Next week, we will be looking at the denial of parentage rule, rescission of acknowledgement or denial of parentage, and registration of births under a gestational surrogacy agreement. Any final thoughts or questions as we wrap up here? Okay, well, we're going to give you all some time back. I really appreciate you being here today, and hope you have a great rest of your day. Thank you, everybody.
Thank you, Derek.
Thank you.
Thanks, everybody.